Hello again. This is a bit different, this one, because we're actually out in the small boat today. So we're on the water and there's a little bit of chop and we're getting tossed about quite a little bit, but we'll crack on regardless. Um, so this one is number 3 in the series, Juice of Use. And I just wanted to go into a bit more depth about contracts and the contract, because it kind of is a bottomless topic, and there's so much to be said about it, and I did say a lot about it in both of the books, but there's obviously so much more to be said, and there always will be so much more to be said. So the problem is the bank, the creditor, bank, debt collector, whoever we're dealing with, they've always got something to say about the agreement, what we agreed to do, the conditions, the terms and conditions, the contract, all of this stuff. Um, and it's always from a perspective of you agreed under the agreement and now you've breached it, so we're entitled to take action, etc. That's generally how they frame the conversation. Um, but it's always been my contention to ask the question, does the contract, the agreement, really exist? And I've sort of always tried to drill to the bottom of that. So anyway, after our little bit of a blooper reel there, when the camera moved, I don't know how far we got. What was I saying? Yeah, so they always harp on about we've breached the agreement, and now they've got the authority or legitimacy to pursue us for a breach of that agreement. So I always drill into it and ask if I can see the original contract agreement with our signature and their signature on it, to inspect it. And there's no point in asking for the original, because nobody will send any original document anywhere, because that is their proof of purchase, for want of a better description. Photocopies of receipts and things like that, while they may be accepted in some places, I don't accept photocopies of any receipt or any contract. I want to see the original with my wet ink signature on it. Um, so I always ask if I can, I'm happy to travel to their offices to go and have a look at it. Um, at which point, when you've asked them, they send a copy of the agreement, and it's generally pages and pages and pages of really poorly photocopied rubbish. There's no other way to describe it. It's terrible, and it cites all the terms and conditions that apply to us, without typically applying to them. It's generally all T's and C's aimed at us. Um, Either way, that's generally what they send. Um, and the last page is usually, as I said, a really poorly photocopied image of a signature. Now I'm going to do a sidebar here, because there's an interesting thing going on with when they claim that it's been signed, and they say, "Is that your signature?" Well, technically, no, it's not my signature, because when I sign anything, I give it to them. So now it's not my signature, it's theirs. And I made it, I made the mark, but now it's no longer my signature because I've given it to them. They are the owner of it. So anyway, back on track. Um, the yeah the ream of paperwork that they send us. The problem there is it's not original issue. It's badly copied photocopies. So it doesn't really fly with me. I want to see the original. It can never contain a wet signature from either party, purely because it's a copy. And even when you do get it, there's very seldom a second signature on it. I hope you're not feeling seasick with all this. We are moving quite a bit. Okay, so if there is a second signature on the document, it absolutely must be the signature of a man or a woman, living man or woman. Uh, the name of the bank or the something manager or the department head. That's not acceptable. It's got to be the signature of a man or a woman. And that's because contract law states that only living entities can, with capacity, can enter into contracting. You've got, two stones couldn't contract together with a fence. Just couldn't happen. So that you've got to have the capacity to sign the contract, and a limited company or a company or a corporate entity does not have any living status. It can't do anything. So it's got to be a man or a woman's signature. If it does comply with the laws of contracting, and there is a second signature on the document, and it's alongside ours, and it is a man or a woman, it still has to comply with the laws of contract signing, which rules out a photocopy. It still isn't legitimate because any document can be easily forged by today's technology. So again, I would really demand sight of the original, and you make it clear that you're happy to travel to them to do so. That should put the fear of God into them. So the big question is, why do they find it very difficult to produce the original document with signatures? Do they still have it? Has it been lost? Did they ever have an original document with all the parties' signatures on? These are questions that we ask all the time, and they're not very forthcoming with answers. But we do know for certain that we signed something. So where is it? Under law, the bank is required to retain our document as a security instrument because the rules state that consideration must be tendered, and consideration is it's part of the deal whereby I bring something to the deal, they bring something to the deal. So, and that's essential for the contract to have equal value to each party. They loan us the credit. They loan us the credit. And it's dressed up as them lending something that's theirs. And we give them a valuable document, a security instrument. And that's our side of the deal. And at which point they hold on to our property as a retainer to ensure that we pay them their money back at the completion of the agreement. And the fact that that document, that agreement, is our property can be evidenced simply by the fact that we created it. There were no disclosures by the bank that they'd agreed with us that it was a gift from us to them. It was always a matter of us completing the paperwork before anything could happen. And that then places an obligation on the bank to keep the document safely until the time comes when we repay the credit. At that point, our consideration, the document, must be returned to its original issuer, which is us. Everybody goes away happy. So when we ask the bank if we can inspect it to confirm that they still have it and they're operating under proper legal practice, there should be no problem, right? They should have it vaulted in a safe place with the thousands of others that are to be returned to their original issuer on settlement of their agreements with the bank. Okay, it might take them a day or two to dig it out and get it to a mutually agreed convenient branch, if there's any branches still open, but there shouldn't be any problem with that. But there is, and it's a huge problem for the bank, and they'll go to any lengths to confuse the issue and delay their response, or even flat out state in some cases that the original agreement has been destroyed. I've heard of that so many times. And now they only have a photocopy. Right, so you destroy the original and retain a photocopy because So where's it gone? At this point, the whereabouts of our property is anyone's guess, but a far bigger issue now confronts the bank and their intentions to recover their alleged outlay. In order to demonstrate that an agreement between the parties exists, the bank must be able to produce it in a court if necessary. Photocopies and images are famously easy to fabricate, and so the original issue must be presented as their Exhibit A to substantiate their claims that we have any kind of business between the parties. And that's before we get to them claiming that we owe them money. And so what if they did manage to get past the judge's rigid adherence to the legislation, and we were ordered to pay the settlement? How would they be able to return the document to us under the strict process of redemption? Redemption is where our property is returned to us after the bank's has been returned to them at full and final settlement of the contract or agreement. And it's the rebalancing of the equation. If they couldn't find it to produce for our inspection, how do they intend to find it to complete the redemption process? So the contract's gone, never to be seen again, and the bank is left high and dry regarding having any legitimate claim against us. And at this point, the bank are also guilty of several charges ranging from simple incompetency to outright theft, and that situation gives us massive leverage against them. So I hope that clarifies the situation somewhat. Please check out the other videos on the channel, and don't forget to subscribe for more juice of use. Cheers.